The Senate will be attentive to the clerk.
Thank you, Madam President. The Committee on Education, to which was referred Senate Bill 430, an act relative to mandatory disclosure by school district employees to parents. Having considered the same, the committee recommends that the bill is ought to pass with an amendment by a vote of 3 to 1. Senator Sullivan for the committee.
Senator Sullivan.
Thank you, Madam President. I move Senate Bill 430 ought to pass with amendment. Senate Bill 430 is a simple bill. It requires all school employees to respond honestly and completely to written requests from parents or guardians for information about their children. This bill ensures that parents' requests cannot be ignored and they will be answered within 10 days. The bill recognizes and empowers the important relationship that exists between parents, educators, and students. The bill also protects student safety and well-being by requiring educators to report to the Department of Health and Human Services if they believe that fulfilling a parent's request could put the student at imminent risk of physical harm, abuse, or neglect. I respectfully ask your support for Senate Education Committee's recommendation motion of ought to pass with amendment for Senate Bill 430. Thank you, Madam President. I'm requesting a roll call.
The first order of business is the committee amendment. Is there any discussion on the committee amendment? I recognize Senator Altshuler.
No, on the bill
On the
itself,
bill?
sorry.
Okay. Senator Prentice? The whole bill, okay. The question is on the adoption of the committee amendment. Are you ready for the question? All in favor say aye. Aye. All opposed say no. The ayes have it, and the committee amendment is adopted. The bill is on second reading. Is there any further discussion or amendment? Senator Altshuler.
Thank you, Madam President. I rise in opposition to the ought to pass motion on Senate Bill 430. As we heard in the testimony, this bill calls back to a 2022 court case when a parent in the Manchester school system inadvertently discovered their child used a different name and pronouns while they were at school. The mother not only disapproved of, but denied her child's transgender status. And this is a fact revealed in the court filings and judgment that this parent, who made her parenting issues everyone else's by dragging the school to court for disclosing every detail that she believed they might know about her child's gender identity. The student had asked to be called by a nickname, not her given name at birth, and to use a different pronoun. And this parent, so aggrieved that the school would deign to treat this student as a human, aggressively went...
One of my constituents is being attacked for being a good parent, and a lot of this that's being said is derogatory toward her and is not accurate information. So I object to this line, to these comments that are being posted right now.
Okay, thank you, Senator. Senator, is there a way?
Madam President, if I might respond.
Yes.
So I have taken what was heard in the testimony in our committee, and additionally, from the Supreme Court case 2022-0537 and filings from the parent's attorney, which are all public record. I have not named any parent. I have named the school district, which we discussed in the hearing, and I am not naming the child. This is a case that is public, has been covered by media, and has gone to not just the Superior Court, but the Supreme Court, and the issue is germane to this bill because it's the genesis of the bill.
Madam
No
President.
names. No names.
Yep. Madam President, there was intent implied to what was just stated. Beyond anybody else in this room, I have more personal knowledge about this case, this family, and the mother's role in this. And I can assure you, first of all, it's well known the child was actually not transgender. She was just going through a hard time. Nope. And that.
This is not debatable. We're going to go into recess. This is not debatable, so we're not going to do back and forth. But I guess we need a few minutes The Senate will come out of recess. Before we went to recess, the Senate was discussing Senate Bill 430, and Senator Altschiller was speaking, so I'm going to recognize Senator Altschiller to finish her floor remarks.
Thank you, Madam President. As I had mentioned, the Superior Court issued an order finding that no fundamental right of the plaintiff, the parent, was infringed because the school's policy does not limit the ability of the plaintiff to raise their child as they see fit. This comes from page 9 of the Supreme Court case 2022-0537. The parent then appealed. This case made its way all the way up to the Supreme Court, and in August of 2024, in a 3-to-1 ruling, the justices declared that the policy that inspired this bill does not directly harm a parent's ability to raise or care for their child. Supreme Court Justice Gordon MacDonald wrote, "The policy does not restrict a parent's ability to learn information from other sources, including the child. The policy does not encourage students to hide information from their parents or prevent students from sharing information. By its terms, the policy does not directly implicate a parent's ability to raise and care for his or her child. Further, the policy does not restrict a parent's ability to learn information from other sources. The policy does not prevent parents from observing their children's behavior, moods, and activities, talking to their children, providing religious or other education to their children, choosing where their children live and go to school, obtaining medical care and counseling for their children, monitoring their children's communications on social media, choosing with whom their children may socialize, and deciding what their children may do in their free time. In short, the school policy placed no limits on the plaintiff's ability to parent their child as they saw fit." Justices Patrick Donovan and James Bassett concurred with Supreme Court Justice MacDonald that school policy did not violate any fundamental parenting rights laid out in the New Hampshire Constitution. So, you would think, case concluded, school policies don't stop, impede, or prevent anyone from parenting their child. Parents need to parent. When their parenting is not yielding the kind of relationship with their children that they want, they have to look inward and change course. Take a breath. Get some advice from outside sources. Parenting is really difficult sometimes. Looking to place blame at the feet of our teachers and coaches is not the answer. It's easy to pass the buck, harder sometimes to face the truth. New Hampshire schools should be committed to securing school environments that allow transgender students, all students, to safely participate as their authentic selves while honoring the vitally important role that parents play in their students' lives. Children are not chattel. They are also people protected under the Constitution. Parenting is incredibly difficult, and just when you think you've made it through one challenging thing, another one crops up. It takes a village to raise a child. A village of extended family, chosen family, teachers, coaches, librarians, community members, all in concert, supporting the children's growth. What no village needs is an unwilling spy network. What no one needs is a vehicle to harass teachers for personal information about students. This bill allows for parents to send a written communication every day, and that has to be responded to within 10 days. For example, "Dear Mr. Teacher, is my child cavorting with so-and-so in class or in the hallway? Have you witnessed them talking to this particular student?" That gets an answer in 10 days. Dear Ms. Teacher, has my child asked you to call them by a nickname? If so, what is that nickname? How do they want it spelled? Where did they tell you it came from? Why, in your observation, don't they want to use their given name? That gets a response in 10 days. Dear Mr. Teacher, has my child attended any club meeting for the Gay Straight Student Alliance? If so, when did they start going? How long do they stay at the meetings? What's your observation there? Respond in 10 days. Dear teacher, is my child eating the lunch that I packed for them? Legit, you can ask that question. You get a response in 10 days. Dear teacher, did my student read a part in the play being read in class that doesn't align with their birth gender? Dear teacher, have you witnessed my child reading books about LGBT people? Have you seen them with a copy of The Sum of Us? Have they been reading books by Ibram X. Kendi, Langston Hughes, Audre Lorde? Please respond, 10 days. Every one of these requests needs to be answered in writing in 10 days. These questions under this bill as written can roll in every day from every single parent, every single day. That sounds ludicrous, doesn't it? Who would possibly abuse a system like that? In fact, we talked about that in the hearing. And actually, we have an example of, of a group that might, based on previous behavior. We have a group in New Hampshire called New Hampshire Cornerstone that has launched a campaign to show people how to threaten a lawsuit if they believe their neighborhood school is not in compliance with a law that went into effect just 6 weeks ago. Not how to be a productive member of your school board, not how to help your school.
Senator, a
yes,
point of
ma'am.
order has been raised.
Oh, thank you.
What is your point of order?
To malign organizations that actually work with us, I think is inappropriate. Thank you, Madam Chair.
Senator, please, it's noted the objection is sustained.
Thank you, Madam Chair. I actually am quoting from communications dated on December 16th and January 4th from New Hampshire Cornerstone and their actual communications. So they have encouraged our communities to threaten lawsuits and further, instead of encouraging civic participation, they're encouraging lawsuits. And further, show you how to get your legal fees with a little button to sign up now. December 16th, January 4th. So when I tell you that Senate Bill 430 is written with vagaries in order to encourage manipulation and abusive behavior, this is not speculation. Senate Bill 430, in my opinion, is about parents unwilling, unable, or uninterested in putting the effort into parenting their children and want to force the schools to parent for them. Talk about a nanny state initiative. Please vote against the ought to pass motion so another motion can be made. Thank you, Madam President.
Thank you, Senator. Senator Prentice wishes to speak.
Thank you, Madam Chair, colleagues. I rise in opposition to the ought to pass motion. Just a little bit of a recap here, Senate or level setting. Senate Bill 430 requires educators, teachers, to respond completely and honestly within 10 days to a written parental inquiry regarding material information about their child and makes violations subject to professional discipline. While transparency, while honesty between schools and families is important, this bill creates some practical and unintended risks that may ultimately have a negative impact on a student, cost a teacher their job, or damage the faith in a local school system. And I'll expand just a little more and briefly with my key concerns. One is overly broad language. So in calling for the disclosure of material information, we're not specific about what this material information is. And we know that material information in itself is data or facts that influence a decision. So is this informal conversations, academic conversations, counseling discussions, student peer interactions, or classroom observations? Providing clarity there, I believe, is necessary considering the relationships and someone's job being on the line. So we need to clarify those in definitions statutorily to be certain, because ambiguity will be difficult and is difficult within statute. Impact on student trust. Students often speak to teachers. We know this. We don't want to get in the way of that. I don't believe we want to get in the way of that. They talk about mental health concerns. They talk about conflicts with other fellow students. They talk about conflicts within their own families, and they may identify a personal struggle. If students believe that these conversations could trigger a request from a family member to a school, to a teacher, to an educator, requiring a disclosure of that conversation, and I know there's a provision related to harm, and I'll get to that, they may be less likely, or overall, not maybe, they will be less likely to have these conversations. Administrative impact. 10 days, I believe 10 days is reasonable, but what we don't, for a response. But what we don't define in here is when it talks about the receipt of the request. Is it receipt of, it says written, is it written by email, is it delivered in person, or is it delivered by the postal service? I think we need to be specific about what receipt actually means in this. And any time that we are asking our educators to respond to requests, it's time that they are not working with our students in the classroom, which is their primary responsibility. So, this could trigger also legal reviews for these responses and more investigations of alleged violations. So there are administrative impacts that could come with this. Professional discipline. We have some, what I believe, and I've stated, are known ambiguities within this, and it could cost an educator, a teacher, if they violate, it's determined they violated the code of conduct, it could cost them their job. Concerns around good faith judgment may lead to professional discipline. Educators may over-disclose or under-disclose because they're trying to work within the boundaries of this. And do they say too much? Do they say too little? Where exactly are they supposed to be on this? And defensive communication, this is key. Defensive communication often replaces, or does replace, educational discretion. Imminent risk of exception is narrow. So we know, and I mentioned this earlier, that if there is a belief that a child is in imminent risk, then there is already a legal framework for reporting for this, and that that is very important. But it talks about physical harm, abuse, or neglect. So this does not account for what we know are also considered harmful and abusive: emotional safety, psychological harm, and situations where disclosure may escalate a family conflict but does not meet the statutory thresholds. So this exception may be too limited to protect vulnerable students. Overall, and in closure here, there are unintended consequences of passing Senate Bill 430. It increases educator turnover. It could increase educator turnover due to compliance anxiety. It encourages over-reporting to Child Protective Services. Reporting is essential, mandatory triggers for reporting. I am not undervaluing that at all, but in being safe, and this is where the over versus under comes into place, in being safe, will we see over-reporting? Reducing student willingness to seek help, increasing formal complaints and legal disputes, and shifting schools towards defensive documentation practices. When did Granite State educators become our foes, not our friends? While transparency and parental engagement is vital. Senate Bill 430, as drafted, risks creating legal ambiguity, eroding student trust, increasing administrative impacts without clear evidence that the current law is inadequate. A more narrowly tailored approach, and we've heard this before, would be a better balance on parental rights, student safety, and an educator professional judgment. And I'd just also like to mention that, we've spent a lot of time since I've served in this body talking about parental rights, and we do talk about student rights, but in these situations, my concern is that the rights of students versus the rights of parents become unbalanced. Students have a right to a voice, to express themselves. This is not a zero-sum game where when one side may gain more, another side may lose something, and that's, I believe, to be considered in this conversation. I thank the body for the opportunity. I encourage you to oppose the ought-to-pass motion and join me in an expedient to legislate. Thank you, Madam President.
Thank you, Senator. The bill is now on second reading. The first order of business is the committee amendment. Is there any discussion on the committee amendment? Oh, we did, I'm sorry. Oh, okay, so the question is on the adoption of ought to pass as amended. Senator Abbas would like to speak.
Thank you, Madam President. I rise in the support of the committee's recommendation of ought to pass as amended. I understand, and we've passed this before in this chamber, and I have a lot of confidence in teachers that if they were to read this bill, they would understand that when a parent is asking about what material information about their child, that they're going to know how to answer that question completely and honestly. And that's the duty that this creates for the teachers. That is it. It's submitted to them in writing, and they have 10 business days to respond to that inquiry from that parent in writing. I mean, complete answers. They grade answers all the time. And if it's incomplete, well, that's sometimes written in the comments on why the grade is lower than the student may have been hoping for. And I certainly hope they can understand what an honest answer is. That is the duty this is creating. It was suggested that parents have other options. They can go to outside sources. I mean, I personally consider a teacher an outside source, but what is the value of that if the outside source is allowed to be dishonest with you? They have no duty to be honest with you when they respond to you, or they can just completely ignore you. Kind of defeats the purpose of consulting with that source. The good news is the overwhelming majority of educators already do this. But for the small minority that takes it upon themselves to subjectively determine that what they believe is okay to withhold, when they think it's okay to withhold information from someone's parents, that's not their place in society to make that determination. That is not their role in society. I don't think I should respond to this parent who's making a good faith inquiry about their child. So please support the committee's recommendation of ought to pass. And I'll just point out one last thing. That legal duty played a big role in the decision the Supreme Court made, because there was no legal duty. This bill will create that legal duty. Thank you, Madam President.
Thank you, Senator. The question is on the adoption of ought to pass as amended on Senate Bill 430. Senator Fenton has a question of
District 24.
Yes.
Thank you. Would you believe that my son is in public schools right now, and when I speak to his teachers, his school administration officials, that they're always honest with me and give me all the answers that I want?
I do believe, and I heard that that should be an underlying assumption. So I'm curious as to why we have to have why we have to have up the potential threat of losing your license for a relationship that supposedly everybody trusts.
Thank you.
okay, Senator Sullivan has a question for.
Thank you, Madam Chair. I have a question for my colleague in District 24.
Yes,
Thank you for taking my question.
sure.
Would you believe that once that child that was referenced in this hearing was removed from the Manchester School District and placed in a charter school, she began to thrive?
I actually didn't think it was appropriate to take anything outside of the printed court cases, so I'm a little reluctant to guess at how that child is doing. I'm sticking strictly with the hearing report, the YouTube, and all of the cases, all of the casework. So I'm not going to speculate on this child.
Thank you, Madam
All right.
President.
Senator Sullivan wishes to speak.
Thank you, Madam President. A mother found out that the Manchester School District was denying her information about her child's behavior in school. She took her child out of school, found a lawyer, arguing that schools should not be lying to parents. The Supreme Court ruled 3-1 that the legislature had never expressly forbidden school district employees from lying to parents about their children. We never thought this law was necessary, but it is. So we're passing a law to say that schools cannot lie to parents about their children. I will answer my previous question. That child, once removed from Manchester Public Schools, is thriving because her mother loved her enough to keep pursuing this until she got the answers she needed. I ask my colleagues to please support, gosh, it's been such a long day already, SB430. Thank you.
Thank you, Senator. The question is on the adoption of ought to pass as amended on Senate Bill 430. Are you ready for the question? A roll call has been requested by, it was a while ago, I think it's Sullivan, and seconded by Senator Lang. You want to do it here? Senator Lang is recognized for a PI.
Thank you, Madam President. Madam President, if I believe, as the bill's sponsor, that we've wandered off on the core purpose of this bill discussion, and if I believe that this bill is simply about the duty of honesty by public employees in our schools, and if I believe it's okay for public school employees to be dishonest with parents, would I vote no? But if I believe, Madam President, as I do, that public school employees should be honest and complete with parents, would I now vote yes to the ought to pass motion?
Thank you, Senator. Senator Perkins-Coca, would you wish to do a PI?
Parliamentary inquiry.
Yes.
If I believe that our educators are good, hardworking people who are honest with parents and who are part of the village that raise wonderful Granite Staters and don't need to have their license called into question over doing their job, would I now vote no?
Okay. Are you ready? This clerk will call the roll.
Senator Rochefort.
Yes.
Senator Lang.
Yes.
Senator McConkey.
Yes.
Senator Waters.
No.
Senator Prentice.
No.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Rishardi.
Yes.
Senator Fenton.
No.
Senator McHugh.
Yes.
Senator Avar.
Yes.
Senator Rosenwald.
No.
Senator Reardon.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Sullivan.
Yes.
Senator Birdsell.
Yes.
Senator Long.
No.
Senator Perkins-Coca.
No.
Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altshuler.
No.
And Senator Carson.
Yes. The ayes have it by a vote of 16 to 8, and the bill is ordered to third reading.